Okay, hi guys, this is the workshop for week 6, infringement and remedies. I understand that it is that kind of midterm slump, and we had one taker for the workshop, and I've said that I'm going to be recording it, so she's going on with her work, and so yay, it's a workshop of me. As I said to the person that turned up, it doesn't really matter because I'm used to talking to myself. I have kids. No one listens to me anyway. So without further ado, let's have a little look at this week's problem. I'm just going to share the screen. Okay, so here we have our well-worn by now problem of Nigel and Roy. We are all well familiar with the facts of the case. And for this week's questions, we need to consider if Nigel and Roy were to sue Fred for passing off or misleading and deceptive conduct, what remedies would they seek and would they succeed? Now, this is a little bit of revision from last week. All I really wanted you guys to do, and I'll just get in a position here so that I can be typing. All I really wanted you guys to do was to recall the elements of passing off. So that is, you need to establish a reputation, and there has to be some kind of misrepresentation that causes deception. That's the whole point of the passing off action, to prevent consumer deception. And there has to be damage. Well, loss, I'll put loss or damage. Loss or damage, or the likelihood of loss or damage. Okay, so here we have Nigel and Roy being worried about Fred's use of hungry eat at max. Now, that's a little bit leading the way that I've got it written there, because, you know, the hungry and the max are large. This is just, as I was describing last week, this is just how I tend to see this sign in my mind's eye, given the one down at Tugun. But it may well just be something like hungry eat at max. Yes, all in similar font, similar writing. We do have the issue that the sign is red and white. Sorry, red and yellow, which is the same as McDonald's and also Hungry Jack's colours. Okay, so first off, reputation. Hungry Max is Fred and Roy's sign that they use, trademark that they use. Have they got much of a reputation in this? Well, we were having a look at this last week, and the facts don't actually tell you how long it is exactly that they've been trading, although you do know that business was booming, so they've got to have been in business for, you know, some length of time. And also it was, you know, enough lapse of time from when they started to now for Fred to have not only worked in the shop for long enough to be exposed to the recipe, to cook the recipe and be confident with it, to get familiar with the burger flipping tool and all of that other kind of stuff that he did, and then secure a lease on a shop across the street, get all of that paperwork signed off, move in, fit out the shop, and then commence trading. So I would hazard a guess it's going to have to be at least a year that Nigel and Roy have been trading. So that's some reputation that they can some reputation they can point to. And like I said, there, the facts indicate there has been a reasonable amount of time for them to be in business. So we have, you know, them getting famous, Fred getting a lease across the road, setting shop up, fitting it out, commencing trading. So there's something there at least that they could show to the court. Misrepresentation. Now, this will probably depend on exactly how Fred used the sign. So did he emphasise the hungry and the max words so that it appeared more similar to Nigel and Roy's hungry max? The facts don't actually tell us. We do know about the red and yellow similarity. So here I think we would probably require a few more facts to say anything with confidence. Need more facts. Assuming that Fred did use the same colours and emphasise the hungry and the max, we do know that we can proceed to, I was going to say, we do know that they could introduce evidence of confusion if that was, you know, if that was appropriate and they had some people willing to testify. Loss or damage, well, we know that they have, Nigel and Roy have suffered damage. How do we know that? Because if you flip up to the facts, his business immediately impacted on Nigel and Roy's profits as his burgers were cheaper. So I'd hazard a guess people may have been going across the road because they thought it was just another Nigel and Roy shop, but it happened to be selling the burgers cheaper. So it seems to me that they should be able to establish that there was some kind of loss. Facts tell us that Fred's conduct immediately impacted on Nigel and Roy's profits. Okay, so we seem to have an action there for passing off. And the question says, what remedies would they seek? Okay, the main remedy here, I mean, when you think about it, what are they really going to want? I would hazard a guess the most pressing thing that they would want would be an injunction to stop Fred from continuing his business operations right across the street. What else would they be seeking? Cogs turning. I think it would be useful in this kind of instance to ask the court for an account of profits. Yes? Because this is where it can come to the fore, yes? Work out what Fred's made and give it back to Nigel and Roy. Elements of an action for misleading or deceptive conduct. We know that there has to be a person must not in trade or commerce engage in conduct that is in all the circumstances misleading or deceptive or likely to mislead or deceive. Okay. Person, well, tick, Fred's a person. We did this last week, so it shouldn't be a surprise. Is the conduct in trade or commerce? Yes. It's a commercial food operation. Is the conduct misleading or deceptive or likely to mislead or deceive? Again, much like your passing off action, this needs more clarification of the facts and how Fred was using his sign. Okay. Have I posed another question there? Remedies. Well, again, I would say injunction. And let's have a look at the remedies that are available, shall we? I didn't get the act up. Well, injunction, we know that we can get an injunction. We might want, and this is an interesting one for the remedies that you can get. Let's see what I'll put here in my infringement and remedies ready reckoner. Down here. Okay. These are the remedies that you can seek under the Australian Consumer Law, where Section 18 is housed, which is what we are talking about, the action for misleading or deceptive conduct. We know that we have actions for damages. We have these beautiful little non-punitive orders. And if you have a look, actually I will try and flip over to this because it's an interesting little provision. Just bear with me as I Competition and Consumer Act. There we go. And beautiful. All right. Now we've got to get down to the Australian Consumer Law in Schedule 2. Oh, no, it was back in the main body of the Act, wasn't it? Maybe not. Here we go. Section 246. So we'll search on 246. There it is. Oh, 246. Okay, non-punitive orders. A court may, on application of the regulator, make one or more of the orders in subsection 2. Have a look at this. Order that they don't engage in conduct. Pretty much an injunction. And where are we? Here, subparagraph D. An order requiring the person to publish at that person's expense and in the way specified in the order and add in the terms specified in or determined in accordance with the order. So that you can actually, Nigel and Roy could seek an order that Fred engage in an ad campaign to dispel the deception caused by his conduct. Yes, awesome. So not only do they get their injunction, they would be seeking, monetary compensation as well. And they would more than likely ask for some kind of rectification of the damage that's been caused. That is, you know, please engage in an ad campaign setting consumers straight as to what happened here and that you are not us. Okay, I've posed an extra little question there. Why not just sue for trademark infringement? I think that would probably be sensible. You'd probably throw that in there as well. We'll do trademark infringement in just a minute. Okay, we'll just save this document. If Mary sued Nigel Roy for copyright infringement, what remedy would she seek? Or what else could she do? Or would she succeed? Okay, what work are we looking at? Let's just flip back to the facts. And we see here Mary designs this menu with a logo with a man, cheeky smile, thumbs up, winking. There's the first work. And the second work, the slogan. Okay. Now, remember, back to our week that we did on copyright, we had a little look at this issue, and so I'll just put here artistic work and the slogan. Now, definitely the artistic work will be protectable. Okay, the slogan, I was just going to say, remember when we were talking about this in the copyright week, there was only a very short sentence, query whether it was original enough to warrant copyright protection. Remember, we had a little look at those cases that said, you know, the title of some journalistic reviews saying something like, you know, the resort that offers precious little was not going to be protectable. The slogan here, as we wrestled with in our copyright week, it says Big Mac's 11 secret herbs and spices make our burgers cool for chewing. Look, and that's a reference to KFC, if you haven't worked that one out. I'm not terribly fancy with my hiding of references. So maybe the cool for chewing edition might tip it over into a protectable copyright literary work. Query that. Okay, so let's look at the artistic work first. What rights does she have and what sections are we talking about? If we have a look at my IP infringement reckoner, we go up here and we see here, okay. Under section 31, I should have put a little 3.1 in there, 3.1. For the purposes of this Act, unless the contrary intention appears, copyright is the exclusive right to and for a literary work. So this would be the slogan. You've got all these rights here. Reproduce in a material form, publish, communicate it to the public, and then in the case of the artistic work, we've only got those three rights there. Produce in a material form, publish and communicate to the public. Okay, so reproduce, publish and communicate to the public. Okay, so let's go back to the other Word document here. So we've got section 31 deals with literary works, and you are looking at Nigel and Fred use the work. Here we're talking about slogan because it's the literary work. On menus, probably on the signage, you know, where they took orders, and so on. They may have, probably did in fact, used in advertisements. So it seems like they would have fallen into one of those section 31 rights. Where is the... there it is. No, it's not. There we go. So reproduction, publication, communication are the rights we'd be after. Section 31(1)(a). All right. So we'd say here, section 31(1)(a), reproduction, communication, publication. Well, here we're looking at section 31 again, artistic work for the logo that she drew for them. Again, used similarly to above slogan, and that will fall within section 31(1)(b). It is, yes. 31(1)(b). All right, so assuming that they're both protectable tests, we remember what the tests are for copyright infringement. And those tests are that the whole or a substantial part of the copyright protected item must have been taken, and we know also that it has to use the essential features of the copyright item. In that case was Autodesk and Dyson. Dyson. Okay, so Nigel and Roy used the exact drawing given to them by Mary. So they took the whole of both the slogan and the artistic work. Slogan, I'll use more copyright language here, the literary work and the artistic work. Okay, so obviously, clearly it had all the essential features of Mary's designs. What is she going to seek from them? First off, she would be seeking damages and possibly an injunction from continued use. Okay. Where do we find this? We know from section 115 sub 2 for copyright infringement, we can seek an injunction and we can seek damages on account of profits. Well, there's no issue of account of profits here. Okay, that's what Mary could do. Let's go back to the document here. Practical alternative. What could she do if she didn't really want to sue for copyright infringement? I mean, it's fairly expensive exercise just to draft up the pleadings and you know, make it to the threshold of the court, let alone the barrister's fees, court time, the whole nightmare of actual litigation. What could you do to cut that short? She could simply oppose Nigel and Roy's trademark application, because it's not going to go anywhere if they don't actually own the thing. Conclusion. Well, we might discuss that down below, because there's a fairly practical alternative that can happen here. For everyone. Okay. Next up. Okay, if McDonald's or Hungry Jack's threaten to sue Nigel and Roy, what remedy would Nigel and Roy seek? What remedy would they seek? Would they succeed? And how would Hungry Jack's and Macca's respond? Well, both Macca's and Hungry Jack's would be suing under Section 120. And again, you'd have to be making arguments that Hungry Max is substantially identical or deceptively similar to either McDonald's trademark or Hungry Jack's trademarks. Difficulties. Well, there wouldn't be any real difficulties for McDonald's and Hungry Jack's. The only ones that I can really think of would be, you know, whether Nigel and Roy's mark was really quite dissimilar to either McDonald's or Hungry Jack's. Remedy. What remedy would Nigel and Roy seek? Well, we see that McDonald's and Hungry Jack's threaten to sue, and there's your big obvious giveaway there. They threatened to sue. So if Nigel and Roy thought that their sign was dissimilar enough from either the McDonald's or the Hungry Jack's signs, registered marks, then they would be seeking a declaration here of unjustified threats of infringement under Section 129. Okay, so remedy Section 129, unjustified threats of infringement. And here, this is the kind of declaration that you'd be seeking if it was fairly clear that the other party actually was not going to file proceedings. So you can only ask for this declaration before proceedings have been filed, and once they file, then you've no longer got this recourse, because it's considered that once you file proceedings, it's not an unjustified threat. There's actual proceedings on foot. Whether or not they succeed is a different matter, but the plaintiff has shown that they're serious enough about the matter to actually spend the money to take the thing to court. Okay. What would Hungry Jack's or McDonald's do? They would just simply file for infringement. I think that would be the immediate response. And I think they've already, or have they, I was going to say, have they opposed the trademark application? No, they haven't. They've just told Nigel and Roy that, you know, they want them to go away. So they haven't actually said what they're going to do if they don't go away, if Nigel and Roy continue with their trademark application. If Nigel and Roy continued with their trademark application, Hungry Jack's and McDonald's would likely oppose the application. And this is where, you know, you come up against the problem of little guys going against the big multinationals. You know, Hungry Jack's and McDonald's have huge monetary spends available to them in order to pursue trademark matters like this. And they would string out the opposition. They would make Nigel and Roy pay through the nose for lawyers to draft up opposition proceedings and arguments for the delegate to hear. So, you know, there are plenty of alternatives open to Hungry Jack's and McDonald's in a situation like this that can make life pretty uncomfortable for a small to medium size operator like Nigel and Roy. So, yes, Nigel and Roy could seek a declaration for unjustified threats of infringement pre any court filing by Hungry Jack's or McDonald's. However, probably the most likely course of action that Hungry Jack's or McDonald's would take before they issued proceedings for infringement would be to just simply oppose the application. Cheaper for them. Not that they really need to save too many dollars. If Roy threatened to sue Fred for patent infringement, what problems would this raise? Well, the problem here immediately that hits you in the face is that Roy doesn't actually have a patent, much like the trademark, doesn't have a granted patent. So it hasn't gone through examination and it hasn't been accepted and entered on the register. It's only once this has happened that you can actually sue for infringement. You can backdate issues. Once you get your patent, you can sue, and you can backdate, for example, you know, your application for damages and so forth to the date of the patent grant. But that's the first and most obvious problem that Roy has here. He doesn't actually have that granted patent, so he'll have to let it go through the examination procedure first, and that may take some time. As we said, the other problem here is that the burger flipper probably wouldn't possess sufficient inventive step for a full standard patent. Okay, you really probably should have filed for an innovation patent. Now, the beauty of that also is that you get your innovation patent pretty much straight away. If he happened to have requested examination at the time he applied for the innovation patent, it goes through a relatively quick examination process, less than 6 months usually, and then you have something that you can sue on. Okay, so that's probably how things should have panned out for Nigel and Roy. If they did manage to get the thing through to a granted patent, and I doubt it, what is the provision? A patent. What is the provision that tells you what the exclusive rights are? That section is section 13. A patent gives the patentee the exclusive rights during the term of the patent to exploit the invention and to authorise exploitation. To exploit and to authorise exploitation. So, section 13, Roy has right to exploit and authorise. Now, can you see any problems there? I'll put this over here. What would Fred do? He would simply say he wasn't exploiting the burger flipper. Oh, here. What's the definition of exploiting under the patents legislation? Let's have a little look. Here we are. There we go. Exploit in relation to an invention includes where the invention is a product, make, hire, sell, or otherwise dispose of the product. So if he took one of the burger flippers and used it only, he'd be okay. If he made one, then he's going to be in trouble. Now, what do the facts say? The suspense is killing me. Okay. Aha! He replicated the burger flipper. So he's not going to be getting out of infringement if Roy ends up with a patent, because it looks as though he has made that burger flipper. So he exploited it, okay? Notwithstanding the fact that he didn't try and sell it, he has made it. Okay, but like I said, if he had just taken one of those burger flippers and was using it, well, there might be an issue of, theft, but there's no real issue of patent infringement if that's the case, just using. Okay, so if he just took the burger flipper, and then you'd have issues of theft. But, as I apparently forgot, facts show he replicated the flipper, which falls within the definition of exploit in section 13. See the dictionary. Okay, so would he succeed? Possibly, but we always have the potential, and this is what I want you to think whenever you think of patent infringement actions, we always have the potential for Fred to argue the patent is invalid in some respects, and here I think he would have a very strong argument that it didn't possess sufficient inventive step. Yes, and so Roy's patent would be wide open for revocation. Okay. That's about all I wanted to say in relation to the patent issues. The last issue is the usual commercial thinking question. Advise Nigel and Roy of commercial issues that might impact practical alternatives they might pursue with the different parties. Well, with Fred, I think it was Joselito that first suggested that they could engage in a media campaign against Fred, saying that he's the copier, he is the second comer to Nigel and Roy's original burgers, etc. They could try and, you know, get the media interested and beat the thing up so that Fred got some adverse publicity. Yes, they could do that. I don't know whether Fred would be open to perhaps a settlement offer. If they just wanted to make him go away, pay him a small amount of money. The problem with that is it would have taken a fair amount of cash to actually secure the lease opposite Nigel and Roy, given that this is, you know, downtown in the city. So, you know, commercial leasing will be quite expensive. There would have been costs involved in the fit out of the shop, training employees and so forth. So the settlement offer is probably going to have to be fairly substantial in order to get Fred out of the way. Or they could sue, as we've discussed above. With Mary, again, probably the most sensible alternative for Mary is the settlement offer, because really otherwise she can sue for copyright infringement and oppose their trademark reach. So she can cause a whole world of pain for Nigel and Roy. Similarly to Hungry Jack's and Macca's, it would really depend for them how similar, the question of how similar Nigel and Roy's mark is to either Hungry Jack's or McDonald's would be the main thing that you'd have to think about here. And like we said above, you know, you really need a bit more facts on this. You'd have to ask Nigel and Roy, do they want to change their mark? That's going to be pretty much the only way that you're going to get Hungry Jack's or McDonald's off your back. If they do nothing, then Hungry Jack's and McDonald's will more than likely oppose their trademark application to start with and then possibly sue. Infringement, or both. And use of the burger flipper. Well, they're going to use Fred's use of the burger flipper. You know what? They could issue a cease and desist letter, which is, you know, your cheap first shot across the bow. If that didn't work, you could always, you could always, you know, threaten to institute proceedings. You probably do that in your cease and desist letter, but really you'll have to, Roy will have to wait until patent issues, or if that gets rejected, apply for an innovation patent. Yes, that's going to be the quick, cheap alternative there. You get that resolved within 6 months. Okay, so that's probably all that we need to really talk about in relation to the practicalities of this particular problem and infringement remedies. If you have any queries or questions, please don't hesitate to email me, post a comment in forums. But apart from that, I hope you got something out of tonight's workshop, and I hope to talk with you sometime soon when the pressure of assessments is not quite so pressing on all sides later on down the track. So with that, I bid you good night, and I hope to talk with you next week. Bye, guys.